Hello everyone, this is Worldwide News and I'm your host Gray Draper, and today we will be going over Supreme Court cases of the United States of America. And without further ado, let's throw it over to Kendall Qualls, Morgan Davis, and Morgan Fly.
Welcome to Worldwide News.
Yep. Oh yeah. Okay. Gotta get started. Thank you so much, Gray Draper, for that amazing introduction and jingle. Well, good afternoon, ladies and gentlemen of America. My name is Kendall Qualls. The date is August 22nd, 1965, and tonight I will be giving you the rundown on the U.S. Supreme Court case, Griswold versus Connecticut. Let's get started. To start off, let's discuss some of the facts on this monumental case. I will inform you that this was an appellate case because it was brought up in Connecticut beforehand. The case reached the Supreme Court on March 29th of this year and is just now ending a few months ago on June 7th. It all started with Estelle Griswold, who was the executive director of the Planned Parenthood League of Connecticut. Estelle was arrested for giving information to married people about available contraceptive devices. Now, she was arrested because, by Connecticut law, it was prohibited to use birth controls or give information about birth control and contraceptives. When this issue was brought up to the Supreme Court, the court had to decide if there was a constitutional basis for the right to privacy. The court ruled with a 7-3 ruling in favor of Griswold, saying that a state's ban on contraceptives violates the Constitution because it violates the right to marital privacy. Douglas gave the statement that people had the right to use contraceptives if in a married circumstance. Supreme Court ruled that based on the 9th Amendment and Pembrose in the 1st, 3rd, 4th, and 5th Amendments, that married couples should have the right to privacy. I will leave you with this powerful quote from Douglas. Would we allow the police to search the sacred precedents of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. This decision was pivotal in helping other issues pass. The case of Griswold versus Connecticut was used in arguments of the Supreme Court case Roe v. Wade, which I'm sure will be a very monumental case in years to come. Thank you so much for your time tonight, folks. I'm going to hand it over to Morgan Davis a few years in the future.
Thank you, Kendall. And now we report live from the year of 1973. And the Supreme Court case, Roe v. Wade, has finally come to an end. Earlier this year, Jane Roe, a citizen of Texas, was seeking an abortion of her child. Texas soon informed her that the state had already made a law that prohibited abortions unless the pregnancy was detrimental to the mother's life. The case was listened to twice because Roe's attorney could not form a strong argument that proved the state law was unconstitutional. The case was originally heard in the U.S. District Court for the Northern District of Texas, but it was eventually appealed into the Supreme Court. The case argued whether it was the government's right to control abortions. Also, it questioned if the Constitution supported the right to privacy of an abortion. The case investigated the Constitution's 14th Amendment to see if the amendment implied the right to privacy of abortions. The Supreme Court ruled 7-2 in favor of Roe. The court decided that a woman's right to an abortion is supported by the right to privacy in the 14th Amendment. The case concluded by stating that the first trimester of the pregnancy is up to the mother to have an abortion, but after the first trimester, the state can regulate abortions. The case determined that the state law was imposing on the civil rights of pregnant women and reduced the state's power over abortions. Therefore, the state government's power was limited because they cannot violate the privacy of citizens. A quote from Justice Harry Blackmun from the majority opinion is, "The right of personal privacy includes the abortion decision, but this right is not unqualified and must be considered against important state interest in regulation." Thank you.
Starting today's news with the case Lawrence versus Texas. It came about on September 1998 and the trial began on March 26, 2003. The case dealt with the state of Texas and a man named John Lawrence. It began when Lawrence was accused of holding a weapon in his home. The police immediately charged into Lawrence's home. After doing this, the law enforcement found Lawrence and another man were having homosexual intercourse. In Texas, sexual intercourse between two women or men was illegal under the homosexual conduct law. Lawrence argued that he did not think his romantic relationship was illegal and he believed the police had violated his constitutional rights by an unlawful search and seizure. The main reason this case became such a big deal was the homosexual conduct law. Some of the main concerns was, do criminal convictions under the Texas law violate the 14th Amendment guarantee of equal protection of laws? And is this the right of consenting adults to engage in private and homosexual activities protected under the Constitution? Finally, the Supreme Court, in a 7-2 decision, ruled that the homosexual conduct law was unconstitutional and state laws banning homosexual intercourse was a violation of the right to privacy. With this case, it ruled a violation of the Equal Protection Clause of the 14th Amendment. With the finalization of this case, the 14th Amendment does not allow the government to interfere on the rights of individuals, applying to all people no matter their gender, race, age, or religion. And that is the news for today.
Thank you so much, Morgan Fly, for finishing us off tonight with that amazing case and all the information about it. Well, folks, I hope you learned a lot about 3 very important Supreme Court cases that dealt with issues of privacy throughout America. And I hope that as you go through your night, you think a little bit more about what privacy you deserve. Thank you so much for tuning in with us tonight. I hope you've learned a lot. And as always, we'll see you next time on Worldwide News.
Welcome to Worldwide News.
Starting today's news with the case Lawrence vs. Texas. It came about on September 29th.
Did it start back up?
What's it about, Mom?
There's a blockade a few years in the future.
Starting today's news with the case.
Avery, can you be quiet? I'm trying to record.
Back in 1973, J. Roe, because men can have abortions now, J. Roe